Are you taking the solicitor's qualifying examination? If so, this video is a practice test question to help you prepare for the SQE1 exam. The topic tested in this video is judicial review. To explain this topic, we're going to go through these easy to learn diagrams and go through this practice test question together. So let's start with the nature, process and limits of judicial review. Judicial review allows people with a sufficient interest in a decision or action by a public body to ask a judge to review the lawfulness of an enactment or a decision, action or failure to act in relation to the exercise of a public function. Judicial review should only be used where no adequate alternative remedy, such as a right of appeal, is available. Let's have a look at the supervisory nature of judicial review. Judicial review is reviewing whether a decision-making process itself is lawful and whether the correct legal test was applied. This is what we mean by its supervisory nature, as opposed to an appeal, for example, which reviews the merits of the decision, i.e. whether that legal test was actually met on the facts of the case. In other words, whether it was right or wrong. So there are two takeaways. Firstly, judicial review examines the decision-making process, not whether the decision itself was right or wrong. Secondly, this means that if the judicial review is successful, then a new decision made by the correct process may not be different from the decision made first time round. It's therefore important to determine before starting a judicial review whether, if the judicial review is successful, it's likely to ultimately lead to a different decision for your client or not. So let's look at the available remedies in judicial reviews. The judicial review procedure must be used in a claim for judicial review where the claimant is seeking a mandatory order requiring a public body to do something, a prohibiting order preventing a public body from doing something, or a quashing order nullifying the legal effect of a decision. Other associated remedies which may arise in judicial review proceedings include a declaration stating the rights or legal position of a claimant, a stay of proceedings or injunction. An injunction is often granted as an interim remedy to prevent a public body from acting on a decision. When a matter is urgent, the claimant may seek an expedited permission hearing. And then damages. These are only available if there is an independent cause of action that's available for which damages may be sought. A claim for judicial review may include a claim for damages without the need to bring parallel proceedings. So let's have a look at decisions which may be challenged. A decision must relate to the exercise of a public function in order to be reviewed. These are typically decisions by central government or local government. However, it is sometimes the case that non-governmental bodies exercise functions of a public nature, or, for example, certain quasi-governmental bodies. If the power in question would otherwise be exercised by a governmental authority, then this is a strong indication that the action is judicially reviewable. Conversely, if the decision derives its jurisdiction solely from the voluntary submission of the parties involved, such as a sports club or a religious body, a clearly private body where the agreement is contractual, then it is unlikely to be judicially reviewable. Let's consider standing. So in order to bring an application for judicial review, a party must have sufficient interest in the matter to which the application relates. The most obvious example is where the claimant has made an application to a government authority, say for social security benefit, and that has been refused by the government authority on some flawed basis. Let's say they applied the law mistakenly for some other social security benefit and so did not use the right legal test for determining their entitlement. Well, for the sake of the example, assume that the judicial review is appropriate and that there's no other appeal or alternative remedy. that claimant would have sufficient interest as they are the person affected by the decision. But sufficient interest does not only apply to individuals in these kinds of scenarios. Campaign groups like Greenpeace have been found to have sufficient standing to challenge decisions like that to permit British nuclear fuels to test a new reprocessing plant. The Human Rights Act 1998 also provides a way in which you can show that you have sufficient interest. It states at Section 7 that a person who claims that a public authority has acted or proposes to act in a way which is made unlawful by Section 6, in other words, the duty for public bodies to respect human rights, may bring proceedings against the authority under this Act in the appropriate court or tribunal, or rely on the convention right or rights concerned in any legal proceedings, but only if he is or would be a victim of the unlawful act. So one way of demonstrating that you have sufficient interest is to show that you are a victim of an unlawful act by a public authority which has acted or proposes to act in breach of your convention rights. But do remember that other bodies, like campaign groups, may also be able to show sufficient interest. Let's consider time limits. The court's permission to proceed is required in a claim for judicial review. So the first point is the pre-action protocol for judicial review. The claimant should normally send a pre-action letter before commencing proceedings if the time frame permits it. So in terms of timeframes, let's begin with the claim form. The judicial review claim form must be filed promptly and in any event no later than 3 months after the grounds to make the claim first arose, unless any other enactment specifies a shorter time limit for making the claim for judicial review. For example, there's very specific planning cases or procurement cases where a different time frame applies. So the rule on filing the claim form is that it must be filed with the court within 3 months after the grounds to make the claim first arose. When it comes to service, the claim form must be served on the defendant and, unless the court directs otherwise, any person the claimant considers to be an interested party within 7 days after the date of issue. So that is the rule on service. You serve within 7 days of filing the claim form. Then we need to have a look at the acknowledgement of service. So what does the public authority do when they receive the claim form? They respond with what's known as an acknowledgement of service. The civil procedure rules state that any person served with the claim form who wishes to take part in the judicial review must file an acknowledgement of service. Any acknowledgement of service must be filed not more than 21 days after the service of the claim form and served on the claimant and, subject to any direction, any other person named in the claim form as soon as practicable and in any event not later than 7 days after it is filed. The time limits under this rule may not be extended by agreement between the parties. So once you are served with the claim form as a public authority, you have 21 days to file an acknowledgement of service with the court. You then have a further 7 days to serve it on the claimant. Grounds. Let's consider the grounds on which a judicial review can be brought. Illegality. Illegality arises where the decision maker applies the wrong legal test, sometimes referred to as misdirecting itself in law, or acts outside the limits of its power or jurisdiction. An enactment may be unlawful if it is, for example, a piece of secondary legislation which is made outside of the enabling provisions of the primary legislation. An action under a public law function may also be quashed if it is exercised for an improper purpose, such as, for example, police using powers for private purposes. Illegality also encompasses improper delegations of power, delegating a power where the delegation is not permitted. Irrationality. Irrationality includes Wednesbury unreasonable. This means a decision or act so unreasonable that no reasonable authority could ever have come to it. This also includes when reaching a decision taking into account irrelevant matters or not taking into account relevant matters. It also includes making a material mistake of fact. Procedural impropriety. This generally arises in the context of a failure to follow a prescribed statutory procedure. Procedural impropriety could also include a failure to observe the principles of natural justice in an adjudication process, such as a decision maker demonstrating bias. For example, where a consultation process is required by law, this could also include a failure to adequately consult affected parties. Let's consider legitimate expectation. A public authority may, in certain cases, be held to a clear and unambiguous representation that a procedure be followed or benefit provided. This is generally only possible where there has been an abuse of power and the individual has relied on the representation to his detriment. The expectation must be legitimate, so there can be no expectation that the public authority will act unfairly, for example, or beyond its powers. Let's look now at a question of the kind you could get on this topic in the SQE1 exam. Which of the following statements best describes Wednesbury unreasonableness? A decision or act so unreasonable that no reasonable authority could ever have come to it, not made on sufficient or properly considered evidence, wrongly decided on its merits, undermining the public good. The answer is A. A decision or act so unreasonable that no reasonable authority could ever have come to it. I hope that was helpful. If you would like to get access to the first part of our full SQE preparation course for free, just click on the link below. See you in the course.